Hello, everyone. My name is Julia, and I'm joined today by my colleague, Alan. We are both attorneys with the Women's Law Project at the National Network in Domestic Violence. Today, on this online information clinic, we'll be having a conversation about enforcement of restraining orders. In the description of this video, you're also able to find the links to the slides and materials in both English and Spanish. I wanted to tell you a little bit about myself before we start this conversation today. Again, my name is Julia, and I've been with the Women's Law Project for about 5.5 years, but before that, I represented survivors of domestic violence in restraining order cases and other family law matters. Alan, would you mind introducing yourself as well?
Of course, Julia. Hi, everyone. My name is Alan. You may remember us from the last video. I've been with Women's Law for a little over 2 years now, and before that, I litigated family law cases, both in private practice and with a legal aid organization.
Thanks, Alan. Can you start our conversation today by talking a little bit about the legal benefits of having a restraining order?
Yes, I can. So there are many legal benefits to have a restraining order. It can be a really effective tool for someone who's experiencing abuse. You can go to the courthouse and file for a restraining order, as we talked about in the last video. And if the judge decides to grant that restraining order, he can issue you provisions like that the abuser cannot have contact with you, that the abuser has to stay away from you. It can sometimes include children as well as protected parties. It may include some custody and visitation arrangements. It can award exclusive occupancy of a shared home. If you have children and there is a visitation arrangement, then sometimes it allows for some contact between the parties to make those arrangements. But in essence, what the restraining order does is it criminalizes behavior that isn't otherwise illegal. So for example, it wouldn't be illegal normally for an abuser to drive by your house. But if you have a restraining order that says that the person has to stay away from your house, and then they're driving by your house or they're knocking on your door, then what wasn't illegal before is now a criminal act. And the person who experiences that is able to take steps to try to enforce the order, which we'll talk about later. I do want to mention, though, too, that a restraining order isn't necessarily designed for every situation. It can be an effective tool, definitely, but you want to make sure that you safety plan with an advocate before you go to file for a restraining order, because in some situations, the abuser might retaliate, or there could be some other considerations as to why it's not necessarily the best option for you. So make sure you talk through that with an advocate if you have one, or a lawyer if you have one. If not, it's okay to file for a restraining order without a lawyer. But if you do have a lawyer, then make sure you have that conversation. It's also a nice tool for potentially for communities that may not have great relationships with police, which of course that does happen, because oftentimes in most states you can file for a restraining order without involving law enforcement. I would say the vast majority of states. So a person could file on their own. The police don't need to be involved. And then if there is a violation, then the person can take some steps to enforce that order on their own. Also, I wanted to mention that citizenship is not a requirement for filing a protection order. So a person who may not want to call the police for that reason may be able to go and file for a civil protection order without involving law enforcement again. So those are some of the benefits. And Julia, do you mind maybe talking about how and when a person could report a violation?
Sure, yeah. Thanks, Alan, for talking about, the benefits of having a restraining order. And once one is issued, there could be a situation where an abuser actually violates that order, and the petitioner or the victim will want to know how to be able to enforce it. So for a restraining order to be enforced, the abuser does have to have notice of the order. This means that the abuser has to be served with a copy of an order. And this is generally because you can't legally require someone to obey an order that they didn't have notice of, since they wouldn't know what things they are prohibited from doing. So if the abuser does have notice and then violates the terms of an order, there are a couple options for reporting those violations. Generally, these two options are going to be filing a motion for contempt, and the other option is going to be calling the police. So if a person is going to file a motion for contempt, they're basically asking the judge to enforce the terms of the order. If the abuser violates the term of the order that deals directly with the protection of the victim, these are going to be the terms that you discussed, Alan, things like staying away from the victim, not contacting the victim, the order to not abuse the victim. If any of those are violated, in those situations, the victim might want to call the police to actually report that violation. But if the abuser violates a term that doesn't involve the direct safety or protection of the victim, those might be things like violating the order to pay child support that might be included in a restraining order, or violating any term to pay mortgage or some kind of other spousal support, or not going to batterers intervention treatment, something like that. Those will usually be reported directly to the judge through a motion for contempt. So, I just mentioned that these violations that deal with the protection of the victim are usually going to be reported to police. But Alan, as you said, not everybody wants to interact with police. There might be communities who don't have good relationships with police, or have experienced harm, or have some other reason that they don't want to make a police report. And in that situation, you can generally also report those violations directly to the judge through a motion for contempt. So I did want to mention that. And then in a lot of states, the judge may forward the case directly to prosecutors to investigate whether or not to bring criminal charges in that situation. So Alan, once a violation is reported, can you talk about, in your experience, what relief is usually available to a victim whose restraining order has been violated?
Absolutely. Before I jump into that, I just wanted to mention quickly that when a person does file a violation petition or wants to file a violation petition, the process for doing that might depend on the state. In some states, a person can just walk right into the courthouse and they can file their own violation petition. In other places, they may have to work through a prosecutor's office or an attorney general's office, depending on the state or the territory. So you can look up that information on our womenslaw.org website, or you may be able to call the courthouse and ask what the process is, but keep in mind it could vary by state. Then when you do go and you file if you file a contempt petition, there's a few different kinds of contempt. There's civil contempt and there's criminal contempt. So criminal contempt would be where an abuser could potentially be sentenced to jail or fines because of the violations. Whereas with civil contempt, more often the judge will take some other administrative type action to try to keep the person in line with the order. So that could be extending the order, it could be changing the terms of the order so that way they're more beneficial to the protected party. So it depends on first of all, how you file the violation petition, or how you report the violation, whether it's through the court itself, that would be a civil, potentially criminal. If you call the police, then that would be a criminal violation. And so also, I wanted to mention too that a judge who's going to be issuing some criminal sanctions, that abuser then has what's called due process. So they may have the right to be given notice of the hearing. They may have the right to present their own witnesses and argue against the filing or a finding of criminal contempt. Whereas with a civil case, it's a little bit lesser of a burden for the person who's filing. Usually it's a preponderance of the evidence, meaning it's more likely than not that the violation occurred. Whereas in a criminal case, it would be beyond a reasonable doubt, which is a higher standard. So there is a difference between civil and criminal contempt. Not really something that the person who's filing is going to need to worry about so much, but just as you're going through the process, it's important to understand what's going on so you know where you stand and what the possible outcomes could be for your case. I saw it was a slide on the screen too where I was talking through some of these issues. But Julia, if you want, you can mention who's bound by the terms of a restraining order.
Yeah, sure, Alan. So generally, when a restraining order is issued, the terms of the order are actually going to apply to the abuser rather than the victim. So for example, if a restraining order states that the abuser is not to contact the victim, but then the victim may reach out to the abuser for whatever reason, this isn't usually considered a violation of the order. The abuser is the one who's actually responsible for obeying the order. However, with that said, there can be some negative consequences to a victim for disregarding the terms of the order or facilitating contact when an order says not to. So for example, if a victim has a temporary order and hasn't gotten a final order yet, making contact can possibly hurt their chances of getting the final order. The abuser or the abuser's attorney, if they have one, could try and use this information in court against the victim to try and convince the judge that there really isn't any need for an order because the victim has made contact. If there is any criminal case for the abuse, or if there is any criminal case for a violation of the order, then maybe the prosecutor may decide not to move forward with the criminal case, or a jury could decide not to convict the abuser if they know that the order was disregarded by the victim. And then this might be a little bit less common, but it's something to keep in mind. In some states, there might be legal consequences if the abuser accuses the victim of contacting them. So for example, if the victim could be accused of actually harassing the abuser, and then there might be a separate case started against the victim, or the victim could be held responsible for aiding and abetting in some kind of criminal act. So those are just things to keep in mind in terms of who is actually responsible for obeying the order. Alan, I was wondering if you could also talk about what the police or the judge might do after a violation is reported.
Well, Julia, usually if a violation is reported to the police will investigate as to whether or not a violation actually occurred. They'll discuss with the victim what actually happened. They'll take a look at whatever evidence they have. So if they have, for example, if it's a no contact order, and if you have text messages showing that the person who is not supposed to contact you has been contacting you, then you're going to want to show those to the police so that they know that, yes, this person did contact you. If there are witnesses, they'd like to talk to other witnesses. And then if they think that a violation did occur, police can make an arrest. They can warn the person. This can depend on the state as well. States vary sometimes in their response to this. So in some states, it's mandatory that the police make an arrest if they think a violation occurred. In other states, police have discretion as to whether or not they issue a warning, if they make an arrest, or if they take some other action. But that could also depend on the severity of the violation. So if there's some ambiguity and it may or may not be a violation, then the police may not make an arrest. But if it's very clear that a violation occurred, for example, if there was an assault that took place, or if you have a photograph of the abuser driving by your property, like I mentioned earlier, then more likely they'll take it more seriously. So it depends on the situation, and it also depends on the state's rules. If the person files a violation petition with a judge, then typically it'll be put on the calendar for a court calendar for a hearing, and then the person can come in and they can show the judge the evidence that they have that a violation occurred, and then the judge would then be able to take steps that they believe are necessary if they think that a violation did occur, which would be things like I talked about earlier: extending the order, changing the terms, making it a no contact instead of a non-harass, or making it no stay away rather than a non-harass. So there's some things that the judge can do if they believe that a violation has occurred. And then also if it happens more than once, or if it's a serious violation, then the judge may be able to do more serious sanctions like jail time, like I mentioned before. So those are some things that the judge can do. And Julia already mentioned that another thing the judge or the police may consider is how the victim themselves were involved, potentially in maybe trying to initiate contact, or taking other steps to try to get the person, the abuser, charged with the violation. If they think that that's happening, then they may be less likely to enforce the order. But still, technically, it should be a violation because our restraining orders typically go one way. That would be against the abuser. So if there's unintentional contact, then it wouldn't be as much of an issue. Sometimes the parties walk into the grocery store at the same time. What's supposed to happen in those instances is that the abuser is supposed to leave, but it wouldn't technically be a violation if it's unintentional. If it happens over and over again, then the argument can be made, certainly, that it's intentional. But if it's a one-off and it happens innocuously enough, then may or may not be a violation. So again, these are all really going to be case specific and state specific. But if you believe that a violation has occurred, then you have some options, maybe calling the police or filing your own violation petition. And I know this happens too from state to state sometimes. So that can be a little bit tricky. Julia, do you want to talk about that for a minute?
Yeah, of course. You could end up in a situation where perhaps you have a restraining order in one state where you live, but you decide to move to a different state. So under federal law, there's a legal concept known as full faith and credit, and that should apply to restraining orders. So full faith and credit means that the new state that you move to should actually recognize and enforce the order that was issued in the original state that you lived. And for a restraining order to be granted full faith and credit, there are a couple requirements that you're going to want to be aware of. Federal law actually does require that the order be issued after the abuser has notice and the opportunity for a hearing. There are some situations where an order can be issued by default, which might mean that the abuser didn't appear for the hearing. And if the abuser had notice and had a chance to come to the hearing, that's still a valid order that can be enforced. So that's just something to keep in mind. There are also going to be some states that actually have laws and rules about registering or filing the out-of-state order when you move. So you might want to check out if the state that you move to has some kind of requirement that you actually have to register the order. A valid order really should be enforceable regardless of whether it's registered, but it's still going to be helpful for you to know if you really do need to make the new state aware that you have this order. And we do have some information about this on our website. So I want to share my screen for a moment just to show you where you can find that. So if you go to our womenslaw.org website, I'm just using California as an example, and you can actually go to our California restraining orders page, and there's a section called Moving to Another State with a Restraining Order. And here you'll see there's going to be questions that are specific to each state that have some information about whether or not you need to register the order or some other things that you might need to consider when you move to a new state with a restraining order. Some other things that you might want to think about if you're going to move to a new state with an order is that before you move, you might want to go to the court that issued your order and actually get a certified copy of the order. For the most part, you can do that by going to the clerk's office and requesting a certified copy. The clerk should know what that means. Usually they will print out a copy and there's going to be some kind of stamp or some kind of indication that it's an official copy from the court. The other thing you might want to think about doing is letting the court know that you're moving. And if you have the new address that you're moving to, you can give it to them then, or you can contact them later perhaps to update your address. But this can be helpful in case there are any updates or changes to your court case. Perhaps the judge takes some action in your case and you would want to be notified about that, or maybe the abuser files a motion in your case and you're going to want to be notified about that. So you might want to update your address so that you can get those notifications. You can, for the most part, ask the clerk for some way to keep your address confidential. So if you're moving for safety reasons, or if you just don't want your new address to be public, or you want to make sure that the abuser does not get a hold of your new address, you can ask that that address be kept confidential. So those were the main things I wanted to cover today. I don't know if there's anything else you wanted to talk about, Alan.
No, Julie, I think that's pretty much covers it. I want to thank everyone for joining us today on this OIC about enforcement of restraining orders. And if you found this information helpful, then we'll have another one here soon that talks about common issues with restraining orders. So be sure to check that one out as well. If you have further questions, we do have an email hotline, which is confidential and anonymous. And it's a way you can ask legal questions that relate to domestic violence, sexual assault, or stalking in Spanish or English. So the hotline is staffed by attorneys, including us on the women's law team. So you may get one of us responding to you on the email hotline. So if you have further questions, don't be afraid to reach out to us on the email hotline, and be sure to check out the other videos. All right, thanks so much.
Thanks for chatting with me today, Alan, and thank you everyone for joining us.